On June 27th, 2026, the United States Supreme Court finished what it started 4 days ago, and almost nobody in mainstream media is telling you the full story. The 7-2 emergency ruling that dropped on June 23rd was not just a legal decision. It was a detonation inside the foundation of how American power actually works. And now, 4 days later, the shockwaves are hitting harder than anyone predicted. Federal agencies are restructuring their legal strategies in real time. State attorneys general are filing motions by the hour. And the White House is doing something it almost never does, staying quiet and hoping you don't notice. I am going to walk you through every single layer of this, what the court actually ruled, why 7 justices, crossing every ideological line that is supposed to divide them, agreed it was urgent enough to act in the middle of the night, what it means for immigration, for elections, for your gun rights, for the environment, for the daily policies that touch your life, whether you follow politics or not. And I am going to tell you the part that the cable networks and the legacy publications are deliberately soft-pedaling, because understanding it completely changes how you see the American legal system. If you have found this channel because you are tired of being managed, tired of being given the version of events that powerful institutions decided you were ready to handle, subscribe right now, not as a favor to me, as an investment in yourself. Because what happened on June 23rd is the kind of structural shift that gets buried under tomorrow's outrage cycle if you are not actively fighting to keep it visible. Subscribe, and let's get into it. To understand why this ruling hit the system so hard, you have to understand the weapon it just took away. For the better part of 3 decades, there has been a mechanism operating inside the American legal system so powerful, so routinely abused, and so conveniently ignored by the people who benefited from it that most Americans have never heard it named directly. It is called the nationwide injunction, and it has been, without exaggeration, the single most consequential tool in American political warfare since the early 1990s. Here is how it works in plain language. A president issues an executive order, a federal agency finalizes a regulation, a state passes a law, someone doesn't like it. That someone, a nonprofit, a state government, a corporation, an advocacy group, files a lawsuit in federal district court. Not just any district court. The specific district court where they have calculated the judge is most likely to see things their way. And then they ask that judge, one person, one unelected jurist with a lifetime appointment in one city in one corner of America, to issue an order freezing that policy for the entire country, not for the plaintiffs, not for the state where the case was filed, for all 330 million Americans, immediately, before the case is argued on its merits, before any full hearing, before any real examination of whether the underlying legal theory holds up under scrutiny. Think about what you are actually looking at when you lay it out that way. You are looking at a system where one judge in one courthouse can veto national policy on an emergency basis, and where the only thing separating that veto from permanence is whether the losing side has the resources and the legal firepower to fight it all the way up the appellate chain, a process that takes years and costs millions of dollars. That is not a bug in the American legal system. That is a deliberately exploited feature. And both political parties, every major advocacy organization, every well-funded interest group in this country figured that out and played the game without apology. The Trump administration's travel bans, gone nationwide by a single district judge in Hawaii, Biden-era immigration enforcement priorities, gone nationwide by a single district judge in Texas, clean energy regulations, gone, red flag gun laws, frozen, voting rules blocked, border policies halted, the same weapon pointed in every direction by every player in every administration for 30 years, and the Supreme Court has been watching it, growing increasingly alarmed, dropping signals in rulings like Labrador versus Poe, waiting for the right moment and the right case to draw a line that could not be ignored or lawyered around. June 23rd was that moment. 7 justices. Let that number settle before we move forward. Not 5. Not a bare majority with 2 justices holding their noses and signing on reluctantly. 7. Justices who disagree on abortion, on affirmative action, on the administrative state, on the scope of federal power, on nearly every major constitutional question of the last decade, agreed that this particular practice had gone far enough, broken enough, damaged the constitutional structure badly enough, that they were willing to issue an emergency order in the middle of the night to stop it. That kind of cross-ideological alignment at the Supreme Court level does not happen by accident. It does not happen because of politics. It happens because the justices looked at something and saw a genuine, serious structural problem that transcended the usual fault lines. The case at the center of this Trump versus Casa involved a challenge to birthright citizenship policy. But the ruling that came out of it was about something much larger than birthright citizenship. It was about the question that has sat underneath American constitutional law for 30 years without a clean answer. When a court rules in favor of plaintiffs in a lawsuit, how far does that ruling actually reach? Does it protect the specific people who brought the case, or does it rewrite national policy for everyone? The court's answer, delivered across 7 votes and multiple written opinions, is as clear as the Supreme Court ever gets. Injunctive relief must be proportional to the injury. It must protect the parties before the court. It cannot be used as a mechanism for manufacturing national policy outcomes through judicial backdoors, available only to those with the right legal strategy and the right filing location. Justice Neil Gorsuch's concurrence is going to be quoted in law school classrooms and federal courtrooms for the next 50 years. Read it carefully, and you will understand why. Gorsuch looked at what federal district courts have been doing with nationwide injunctions, and he called it what it is. He said those courts have been acting as mini legislators, not as judges applying law to facts, as lawmakers, unelected, unaccountable, imposing national policy based on one lawsuit from one set of plaintiffs in one jurisdiction with zero democratic mandate and zero mechanism for the 330 million people affected to push back. He grounded his argument in what legal scholars call the traditional limits of equitable relief, the foundational principle that a court's remedy must match the injury. If you are harmed, a court can protect you. A court cannot use your harm as the pretext for dictating terms to an entire country. Gorsuch is not writing as a conservative protecting a conservative outcome. He is writing as a constitutionalist who looked at decades of judicial overreach and decided the record needed to reflect permanently and unambiguously that it was wrong. Courts have been doing something they were never authorized to do, and 7 members of the highest court in the country have now said so on the record. Justice Sotomayor's dissent, joined by Justice Ketanji Brown Jackson, deserves honest engagement. She is not wrong that this ruling creates real complications. Her central concern is what legal scholars call the patchwork problem. If courts can only protect the specific plaintiffs in a given case, you end up with a country where the same federal policy is enforceable in Georgia, blocked in California, contested in Ohio, and unresolved in Montana, all at the same time. Where your legal rights as an American depend not on the Constitution or the law, but on whether you happen to be a party to the right lawsuit filed in the right courthouse. That is a real concern. Anyone who dismisses it without engagement is not taking the ruling seriously enough. But here is why the majority was right not to let that concern override the core constitutional problem. The alternative Sotomayor is implicitly defending the system of nationwide injunctions that the majority just rejected is not actually solving the inequality she is worried about. It is producing a different kind of inequality, one where your legal reality depends on which side has the better legal team, the better judge shopping strategy, and the more sympathetic jurisdiction on speed dial. One where national policy is decided not by Democratic majorities, but by whoever gets to the right federal courthouse first. If the absence of nationwide injunctions creates chaos, the answer to that chaos is Congress. It is state legislatures. It is the democratic process doing the work it exists to do. The answer is not to hand permanent policymaking authority to unelected federal judges as a substitute for democratic governance. That is not a conservative argument. That is a constitutional argument. And 7 justices made it. Now let's talk about what this means for your life. Because this is not an abstract constitutional debate. This ruling touches every major policy arena in American life, and the effects are going to be felt on the ground, in real communities, in real ways. Immigration. Immigration has been the most injunction-saturated policy battlefield in American law for the past 15 years. Nearly every major immigration enforcement action by the Trump administration was frozen by a nationwide injunction. Nearly every major enforcement relaxation by the Biden administration was frozen by a nationwide injunction from the other direction. The policy whiplash has been staggering, not because of Congress, not because of elections, but because of dueling district court orders issued from opposite ends of the country. Under the framework the Supreme Court just established, that whiplash becomes dramatically harder to manufacture. A single district court in a sympathetic jurisdiction can no longer freeze immigration enforcement nationwide on behalf of plaintiffs from somewhere else. States cannot have their immigration enforcement authorities suspended by injunctions triggered by lawsuits that have nothing to do with them directly. The battleground for immigration policy just moved. It moved from federal courthouses back to where the Constitution always said it should be, to Congress, to the executive branch with democratic accountability, and to the democratic process of elections. Election law has been drenched in nationwide injunctive warfare for over a decade. Voter ID laws, absentee ballot rules, redistricting maps, early voting rules, ballot drop box regulations, all of them at various points subjected to sweeping nationwide blocks issued by district court judges acting on the basis of lawsuits from limited sets of plaintiffs. The ruling makes it dramatically harder to use a single lawsuit to freeze election rules nationwide. That means election policy is going to have to be won and lost in state legislatures in Congress through the actual political processes the Constitution established, not in the strategic geography of federal courthouse shopping. Whether you think that is good or bad depends on where you stand politically. But understand what is actually changing. The mechanism for overriding democratic outcomes through judicial shortcuts just became dramatically less available to everyone. Guns. Multiple states have passed significant gun regulations over the past several years. Red flag laws, background check expansions, assault weapons restrictions. In multiple cases, those laws were hit with nationwide injunctions before they could function, frozen at the district court level on the basis of Second Amendment challenges that had not yet been fully argued. That dynamic has now shifted. A state that passes a gun law has significantly more runway to enforce it while legal challenges proceed. Challengers still have the right to sue. They still have the right to seek relief. But the relief they can obtain is proportional to their actual injury, not a nationwide freeze on everyone else's policy choices. Environment. This may be the arena where the long-term consequences are most profound. Environmental regulations have been one of the most active battlegrounds for injunctive warfare in American legal history. The Clean Power Plan, methane emission rules, water quality protections, species preservation regulations, all of them at various points subjected to sweeping district court injunctions that froze them nationally before implementation. If you have been relying on federal courts as the primary line of defense for environmental protections that Congress has been unwilling or unable to pass, this ruling is a serious blow to that strategy. The battleground shifts to legislatures, to elections, to the democratic process. That is harder, it is slower, it will produce outcomes that frustrate people on every side of this debate. But it is the process the Constitution actually created. The political response to this ruling has been telling in every direction. The White House released a statement that was a masterclass in strategic vagueness, language about reviewing the court's order, language that could mean anything and therefore means nothing. That kind of carefully constructed ambiguity is what institutions produce when they have been hit somewhere it hurts and are not ready to acknowledge the damage in public. Inside the Department of Justice, the word being used privately is not setback, it is not complication, it is earthquake. Because that is what it is for an agency that has spent years using favorable district court injunctions as a substitute for legislative action, as a way to achieve and protect policy outcomes without having to win Democratic majorities. State attorneys general moved with a speed that reveals how prepared they were for this moment. Within hours of the ruling, AGs from multiple states had already filed supplemental briefs in ongoing cases, citing the Supreme Court's decision as direct authority. Legal teams that had clearly been watching and waiting deployed it immediately, arguing that the court had now formally affirmed what they had been contending all along. that states have the right to enforce their laws without being subjected to blanket injunctions from federal judges, substituting their policy preferences for democratic outcomes. And here is what the mainstream coverage is largely failing to make clear. This ruling does not belong to one party. It does not advantage one ideology in any permanent sense. In this specific political moment, with the current configuration of power in Washington, the states most energized by this decision are red states challenging federal authority. But the dynamic flips entirely with the next election. When Democrats hold the White House, it is red state AGs using nationwide injunctions to freeze progressive federal policies. When Republicans hold the White House, it is blue state AGs doing the same thing in the other direction. Both sides have screamed about judicial overreach when the other team held the gavel. Both sides have celebrated it when their team did. The Supreme Court looked at all of them and said the same thing to all of them. Stop. If you want to make policy for this country, win elections, pass legislation, build democratic coalitions, go through the process the Constitution actually established. You do not get to manufacture national policy outcomes by filing a lawsuit in the right zip code with the right judge. That era is over. What happens next is genuinely uncertain in the details, but clear in the broad direction. This was an emergency ruling, not a final comprehensive opinion resolving every question it raises. Lower courts will now have to apply this new, narrower framework to the actual disputes before them, and they will do so knowing the Supreme Court is watching and that sweeping nationwide injunctions issued without rigorous constitutional justification will be reversed quickly. The federal government will push back. It will identify cases where it can argue the national interest is compelling enough to justify broader relief, even under the new framework. There will be circuit court splits, different appellate courts interpreting the new standard differently. Those splits will eventually force the Supreme Court back into the question with a full merits decision. This is the beginning of a legal recalibration, not the end of a legal debate. The lawyers, the advocacy organizations, the federal agencies, they are all already searching for the edges of the new framework, looking for what is still possible within it. But what will not go back is the Supreme Court's public declaration, delivered on the record, by a 7-2 supermajority that crossed every ideological line that is supposed to divide this court, that the practice of using nationwide injunctions as a political shortcut is constitutionally illegitimate. That declaration changes how lawyers advise clients. It changes how advocacy organizations structure legal strategy. It changes how federal agencies calculate risk when issuing new rules. It changes how states think about their legal exposure. The entire calculus of American legal strategy shifted on June 23rd, and the aftershocks are still arriving. There is something deeper underneath this ruling that deserves to be named directly. For decades, both political parties have been quietly, systematically happy to let the federal judiciary accumulate power it was never constitutionally intended to hold, because it was convenient, because it meant you could win without governing. You could achieve national outcomes without winning Congress, without building coalitions, without doing the hard, slow, unglamorous work of persuading your fellow citizens that your ideas were right. You could just find the right judge, file in the right city, get your injunction, declare victory. The Supreme Court just closed that door. What that means, regardless of which side of any political debate you are on, is that American democracy is about to be forced to function more like an actual democracy. If you want change, you have to win elections. You have to pass laws. You have to govern. A favorable injunction is not a mandate. A sympathetic judge is not a democratic consensus. That is a harder system. It is messier. It requires more from citizens, more from elected officials, more from every institution in this country that has gotten comfortable outsourcing democratic responsibility to federal courtrooms. But it is the system the Constitution created, and 7 justices used one of the most powerful tools available to them to push this country back toward it. Constitutional moments do not announce themselves with fanfare. They do not arrive with ticker tape parades or wall-to-wall primetime coverage. They arrive as emergency orders issued in the middle of the night by a court that decided it had waited long enough. June 23rd, 2026 was a constitutional moment. June 27th, 2026, today is the day the full scope of what happened 4 days ago is becoming undeniable to anyone paying close enough attention. The question this ruling leaves open is not a legal question. The courts have spoken. The question is whether the political branches of this country, Congress, the executive, the state legislatures, will rise to what this moment requires. Will Congress build the clearer legal frameworks that could prevent the chaos Justice Sotomayor warned about? Will federal agencies become more disciplined, knowing the judicial safety net they relied on is now substantially smaller? Will state legislatures take their own authority more seriously, knowing they will have to defend their laws through the democratic process rather than winning or losing by courthouse geography? Or will everyone spend the next decade searching for new shortcuts, new workarounds, new ways to game a system that 7 justices just told them to stop gaming? The Supreme Court can draw a line. It cannot make anyone respect it. That part is up to the rest of us. The voters, the citizens, the people who elect the politicians, who appoint the judges, who write the rules that govern our lives. 7 justices in the middle of the night reminded this country that self-government is supposed to be hard, that democracy requires work, that you do not get to outsource your political failures to a federal judge and call it justice. That reminder, issued as an emergency order on June 23rd, felt everywhere on June 27th, is one of the most consequential legal acts in a generation. It will be cited in courtrooms for decades. It will reshape legal strategy across every major policy arena, and it will be felt in elections, in legislatures, and in the daily lives of Americans who may never know the name of the case that changed the rules they live under. You stayed until the end. You now understand something that millions of Americans are being allowed to miss. Do something with that. Subscribe so you do not miss what comes next, because this story is far from over. Share this with someone who deserves to understand what is actually happening in 2026. And leave a comment. Which policy arena do you think this ruling hits hardest? Immigration, elections, guns, or the environment? That conversation matters. Let's have it. I will see you in the next one.